In January 2018, fifth grader Grace Laughlin, who aspired to be a journalist, had a cold the very day that Governor Roy Cooper was scheduled to visit the school she attended, Penny Road Elementary. Grace's mother prodded her to attend because she did not have a fever and doubted that she had the flu. Besides, it was not every day her daughter would have the opportunity to meet the governor. But the 11-year-old remained steadfast in her refusal to attend school, reasoning, quote, "I can't risk getting the governor sick. He has to run the state," unquote. Grace's thoughtfulness and sacrifice was rewarded the following month when Cooper granted the budding reporter a one-on-one interview in his Capitol building office. Afterwards, the governor posed for a photograph with Grace and her mother, Catherine Laughlin. A News and Observer writer brought an account of this heartwarming story to its February 3, 2018 issue. Since June 2012, Dr. Sidney Bihar has been trying to meet with Roy Cooper in his capacity as North Carolina Attorney General and as Governor for the purpose of presenting evidence of 2006 Duke Lacrosse accuser Crystal Mangum's innocence in the death of her boyfriend Reginald D.A, as well as proof of felonious guilt by 4 of the state's main witnesses. This was well before Ms. Mangum's November 2013 trial. For more than 7 years, Roy Cooper has refused to meet with Dr. Haar, and he has not allowed his staff to meet with him. In the meantime, Crystal Mangum has remained wrongly incarcerated while the governor pursues a strategy to run out the clock until Mangum has served her full sentence, then release her and close the case. These stall tactics have worked so far for more than half of her 14-year minimum prison sentence. Governor Cooper was generous with his time and access to the courteous fifth grader and her mother. On the other hand, Cooper has been uncompromising in his determination to avoid any contact with Dr. Haar. Make no mistake. It's not that Cooper doesn't know the truth of Mangum's case, because he does. He just doesn't want to be confronted by them. Crystal Mangum has unflinchingly maintained that during a March 13, 2006 beer-guzzling, strip-oogling party hosted by Duke Lacrosse team members that she was sexually assaulted by 3 partygoers. Following the attack, the African-American NC Central student who was assigned to perform exotic dancing or stripping with another black female left the single-family bungalow on Durham's Buchanan Boulevard amid attendees' shouts using the N-word epithet. She wound up in the emergency department of Duke University Hospital, where she underwent a rape kit examination and told authorities that she wanted to file criminal charges against the 3 unidentified assailants. To assure the case would not be swept under the rug, the Durham District Attorney led the prosecution. He answered media calls for statements and interviews, using those occasions to cajole partygoers to help with the identification of the 3 perpetrators. Since the 50 or so partiers were males and most, if not all, members of Duke's lacrosse team, no cooperation for the Durham D.A.'s office was forthcoming from this tight-knit group of revelers. Also, the team members were quickly bestowed high-powered legal counsel. Taking cues from defense attorneys, the North Carolina State Bar initiated its own investigation of Mike Nifong, this long before any indictments by the prosecution. Excepting the one African-American lacrosse player, all Duke Lacrosse athletes acquiesced to prosecution's request for submission of a DNA specimen, the laboratory process finding no rape kit match implicating them in the attack. From a photo lineup presented by Durham Police to Miss Mangum, she identified 3 individuals with a high degree of certainty as her attackers. They were eventually indicted by a grand jury, arrested, and immediately released after posting bail. At least 2 of the defendants professed to have ironclad alibis, which they claimed would undeniably rule them out as possible suspects. With their attorneys, they attempted to meet with District Attorney Nifong to present their evidence of innocence. But according to them, the District Attorney refused them an audience. A CBS 60-minute segment produced following North Carolina Attorney General Roy Cooper's April 11, 2007 promulgation, in which he dropped criminal investigation in the Duke Lacrosse case and declared the defendants innocent, expressed specifically the alleged frustration of the defendants and their attorneys with Nifong's rebuke of their request for a meeting. CBS correspondent Lesley Stahl interviewed on air the 3 Duke Lacrosse defendants about their unsuccessful attempts to present evidence of their innocence to Durham D.A. Nifong.
She said you had a mustache.
We had photos the night before, the night after, no mustache.
You proved you didn't have a mustache.
Sure.
And still,
we weren't able to show that to the district attorney. We could have proven, but he refused to see them, the photos. He didn't want to see it. And you just look and you're like, you can prove that you didn't have one, and you've got all this other evidence. I mean, you can't put it into words.
In an ESPN 30 for 30 documentary on the Duke Lacrosse case a decade later, Raleigh attorney Wade Smith, who represented Duke Lacrosse defendant Colin Finnerty, supported Dave Evans' assertion that DA Mike Nifong refused to hear defendants' evidence of innocence in the case. Demonstrably,
Reed Seligman had even more reason to be frustrated. He had a rock-solid alibi. He had already left the house and was at a restaurant when the attack allegedly occurred and could prove it with eyewitnesses, cell phone records, and security camera video of him at an ATM machine. Is it true that your lawyer tried to show Mr. Nifong?
Absolutely.
And what? He refused?
He refused. He said, "We are not in the mood to hear fiction." We thought this was going to be over within days.
Did you have the solid stuff?
Everything. Unimpeachable evidence. Things that you could not change, things you could not alter. We said, here, he is going to believe us. He's a district attorney, justice, truth, that whole thing. And he wasn't interested.
Charlotte-based criminal defense attorney Jim Cooney III, who represented Reed Seligman in that same 30 for 30 documentary, also demonstrably demonstrated that Mike Nifong refused to hear evidence of his client's innocence. Lesley Stahl then interviewed North Carolina Attorney General Roy Cooper about Nifong's refusal to hear evidence from the defense.
The lawyers tried to give him this stuff, and he didn't want to take it.
If you're a prosecutor and the defense attorney is willing to come in and give you information about the case, give you what they have, then you say, yes, please come in and let me know what your case is.
During her 2007 60 Minutes interview with then Attorney General Roy Cooper, commentator Lesley Stahl tried to elicit comments impugning Nifong's professionalism by asking Cooper what he thought of Nifong for his unwillingness to hear evidence of innocence.
But we know he said no. What does that say about him as a prosecutor?
Well, that was a mistake. Clearly a mistake.
To his credit, Cooper responded to the action rather than the actor by saying that it was wrong for a prosecutor to refuse to accept evidence from a defense attorney. In 2006, attorneys for 2 of the 3 indicted Duke Lacrosse defendants attempted to present to then Durham D.A. Mike Nifong evidence of their client's innocence, believing that it would absolve them of any guilt in the sexual assault allegations of Crystal Mangum. Mr. Nifong, however, refused to accept their proffered evidence. Because of this refusal by the district attorney, Mr. Nifong was severely criticized by the defendants and their counsels, the media, and by then Attorney General Roy Cooper. 60 Minutes moderator Lesley Stahl emphasized that the Duke defendants had rock-solid evidence of their innocence.
Did you have the solid? Stop it.
Yet Nifong refused to hear it. On ESPN's 30 for 30, Duke Lacrosse defense attorneys Jim Cooney and Wade Smith demonstrated Nifong's rebuke of evidence offered by the defense. Specifically, A.G. Cooper said of Nifong's refusal to hear evidence that
was a mistake. Clearly a mistake.
He went even further by stating that a good prosecutor would welcome any evidence offered by a defense attorney.
If you're a prosecutor and the defense attorney is willing to come in and give you information about the case, give you what they have, then you say, yes, please come in and let me know what your case is.